इक्का करके 4 कर देते हैं तो आप पास हो जाओगे, लेकिन फ्यूचर में क्या करोगे? तो क्या है कि फ्यूचर में यही करना था, डांस करना था, लेकिन पढ़ाई लिखाई जरूरी है क्या? पहले पढ़ लिखाई करना चाहिए, ग्रेजुएशन करो, अपनी अपनी चॉइस है। जैसे हमने पढ़ाई
had an administrative meeting and
we understand
over a little bit.
We fully understand that
My colleagues were actually waiting for me, but I had to hold them back as well.
Your lordships are all under. There's no necessity to even say that.
Just before Mr. Khambata begins,
Yes.
because I believe your lordships was looking at some kind of time estimate. Now, fortunately for me, Milord, some parts of whatever I have given in my written submissions is also part of Mr. Khambata's submission, so I can certainly skip all of that. I estimate Milord about an hour and a half is what I've read.
Yes, Mr.
The way I propose to go about it, I've heard my learned friend, the Solicitor General, and I've got a full report of what has been argued. And I propose, subject of course to what my lords say, to go about it in 4 buckets of arguments. The first, I think it is necessary for me to go into what the group of companies doctrine really is. And it will be my submission that it is a concept which is founded almost entirely, if not entirely, in the law of contract and requires a mutual intention and an implied consent. It cannot exist outside intention. Is going to be my submission.
Mutual intention and
Implied consent of the non-signatory as well as the signatories. Everyone has to consent to the non-signatory being a party. And the second will be that who is a party must ultimately accord or comply with the principles of contract and the provisions of the Arbitration Act. And I will show certain areas where this becomes a little relevant under the Arbitration Act. And it will be my submission there ultimately that the group of companies doctrine will be limited by certain provisions of the Arbitration Act. It's not excluded, but it will be limited. The third is what are the key ingredients of the group of companies doctrine that will be important. And there the submission is going to be that all the judgments ultimately seem to say that the object of using such a doctrine is to find someone who is not signed, but who is what they call a veritable party, effectively a party without a signature. That is the object and end result. And without that end result, there's no intermediate person who can be roped into an arbitration. And finally, and this may be the most important for your lordship sitting in Constitution bench, there are 3 or 4 other very cardinal principles which intersect with this principle. And a balancing needs to be done. And what are those principles? The first is that arbitration is consensual. It is founded only on contract. There can be no arbitration outside contract or consensus. The second is the principle of party autonomy. That arbitration allows parties to decide whether they will arbitrate, and if so, what is the scope of the arbitration and who will be involved in the arbitration. So it is extraordinary. It's not that it can't be done, but it's extraordinary to bring in someone who the parties have not contemplated in the agreement. The third is that there are principles which exist in other branches of the law, which would also have to be balanced. For example, the principle which our Supreme Court has recognized in the Vodafone case, that groups of companies are entitled to structure themselves in a particular manner and hierarchy in order to protect themselves from liabilities and obligations. This is an accepted principle of corporate law. And how is that to then be balanced in a given case with the group of companies doctrine? The balance has to be struck so as not to destroy either one or the other of these principles. Now, in this regard, I want to get 3 or 4 things out of the way straight away. I fully accept that doctrinal concepts or considerations can always be introduced into the Arbitration Act. The doctrine of agency, doctrine of estoppel, doctrine of a group of companies. There's no bar to introducing any of these. And it can't be argued that because sections don't expressly provide for them, they can't be. That can never be in any common law statute. That can never be the position. The second, immediately, that a party need not be restricted to a signatory. That also is I think, fairly clear. The third, that in contract law, a party can become a party to a contract, and a contract can arise by conduct. It need not be signed, or even in writing. It can be an oral contract. And lastly, that who can be made a party to an arbitration agreement will be governed by the Arbitration Act, by Part 1, as far as any India-seated arbitration, whether domestic or international commercial. And the solicitor showed us the recent American Supreme Court judgment, which says the same thing, that it's domestic law that will decide who is a party. So this is a very broad framework, and then of course I have reached conclusions in my submissions, which I commend to my lords. But I would first like to start with the genesis of the group of companies doctrine. Our Supreme Court, in at least 2, if not 3 judgments, has expressly said that this doctrine comes from an arbitral award. And that is the only reason I'm reading an award before my lords. Normally one would never cite an award. But since the Supreme Court has recognized that the genesis of the doctrine is from this award, may I request my lords to see the Dow Chemicals award?
The Dow Chemicals, right?
I have filed a compilation which is serial number 11. My submissions are serial number 5, I'm told, in a listing for my lords. And serial number 11 is the compilation.
Mr. Kambata,
Yes.
as you are opening your argument, I was just going to say, you have said that there could be a group of companies identified as a particular group.
Yes.
And you said that companies are entitled to protect themselves from liabilities.
Yes.
So there could be correspondence, there could be intention, which would say that although I am part of this group, yet I am out of any obligation arising out of contract between A and B. So
Yes.
you will have to sort of, because
I will
this is
go into
something
that.
which you are projecting for the first time.
Yes, I will go into that.
This is important.
No, I will go into that. And how far can a court go in respecting it? There will be some cases where my lord will say, no, the veil has to be pierced.
Correct.
Or this has to be disregarded. I'm not again for a moment suggesting any one of these principles is absolute. There's a balancing to be done. But a balancing has to be done. And what really is happening today, and that is the reason why it's so important the Constitution Bench decides this, is perhaps not in the Supreme Court, but my lords, in the High Courts and in tribunals. The attempt now is to look at a group. If you have an arbitration agreement with one entity, you then look at the entity within that group, which is the most creditworthy or which has the most assets. And sometimes on the most peripheral connection, hardly a connection, certainly not a connection that will satisfy any of these tests, that party is roped into an arbitration in a non-consensual manner. And that is and using the chloro control principles. Sometimes, of course, disregarding them, but my lords are not concerned with the aberrations. My lords are concerned with the principles. And therefore, in any view of the matter, it will become necessary to set down fairly strict parameters. I again accept that my lords should not, down to the last detail, set out a formula. It can't be done. They must leave some play in the joints because these are matters which will alter from case to case. But certain clear guidance is required. Yes. And I will of course come to Justice Roy's question when I'm conscious of that, of how that can be done, and I'll be placing the Vodafone decision before my lords, where this is expressly raised and decided. The Dow Chemicals case is page 1 of this compilation. Do my lords have it?
Yes.
Just the title first. there were 4 claimants: Dow Chemical France, Dow Chemical Company USA, Dow Chemical AG Swiss, Dow Chemical Europe Swiss. The defendant was Isova. Now, the first 2 Dow companies, Dow Chemical France, DCF, and DCC, Dow Chemical Company USA, were not signatories to the arbitration agreement. That is the admitted position. Dow Chemical Company USA was the ultimate holding company of this Dow group, which of course had many other companies in it, but these were the companies that were involved in this transaction. Claimants 3 and 4 were assignees of the original Dow company that had signed the agreement. And they were also subsidiaries of DCC, Dow Chemical USA. Initially, it was signed by Dow Chemical Venezuela, but it was assigned. So claimants 3 and 4 broadly were signatories to the agreement. In the sense that they were assignees, they were claiming through or under, they were not in this broader concept of group of companies. The first 2 Dow companies, DCF and DCC, actually intervened and made claims in the arbitration against Isova, saying we are also entitled to make claims. This was a case of a non-signatory trying to join an arbitration and make a claim. And obviously, Isova took a jurisdictional objection saying they have no right, they are not signatories to the arbitration agreement. In that context, my lords, kindly turn to page 2. And unfortunately, these are only extracts. We couldn't get a complete report of the award. But all the authorities seem to suggest that these are the relevant extracts. The extract at page 2 on the top, on the sources of law that should apply. The first para, considering it is not disputed that the arbitration clauses relied upon by the claimants are contained in contracts that have been signed by neither DCF nor DCC, Dow Chemical USA, that these 2 companies nonetheless maintain that they may invoke them by reason both of the factual context of the conclusion and performance of the contracts and of the fact that these companies, along with the signatories of the contracts, are part of a group of which Dow Chemical USA is the parent company, the 3 others being its daughter and granddaughters, entirely controlled by the firm. That is one undisputed aspect. The next is 3 paras from the bottom of that page. The paragraph starting, considering that the tribunal shall accordingly determine the scope and effect of the arbitration clauses in question, and thereby reach its decision regarding jurisdiction by reference to the common intent of the parties to these proceedings, such as it appears from the circumstances that surround the conclusion and characterize the performance and later the termination of the contracts in which they appear. In doing so, the tribunal, following in particular French case law relating to international arbitration, should also take into account usages conforming to needs of international commerce, in particular in the presence of a group of companies. Turning to page 3, and this I'll read in somewhat greater detail. The tribunal, after accepting that the claimants were all part of a group of companies, then proceeds to discuss the involvement of each of these in the actual transaction. So para 2 at page 3, after a detailed analysis of the contract negotiations, the tribunal continued by considering A, the negotiation of the contracts, considering that in point of fact, DCF, Dow Chemical France, at the time of signature of the 1965 contract, as well as the negotiations which led to the 1968 contract, appeared to be at the center of the organization of the contractual relationship with the companies succeeded by the present defendant. Moreover, this relationship could not have been formed without the approval of the American parent company, which owned the trademarks under which the relevant products were to be marketed in France. So straight away you have a finding that DCF was at the center of the organization of the contractual relationship, and DCC owned the trademarks without which you could never have marketed those products in France. Then that this analysis reveals that neither the sellers nor the distributors attached the slightest importance to the choice of the company within the Dow group that would sign the contracts. It is significant to note that none of the documents produced contains any trace of a discussion on this subject. In reality, all the entities of the Dow group involved in distribution in France understood themselves to be contracting with the distributor or distributors in France, and likewise it was with the aggregate of these entities that the present defendant's predecessors understood themselves to be contracting. So everyone understood that all these companies were really contracting parties. Then that is the time of negotiation, the entering into the contract. Then be the performance. Considering that, as has been mentioned above, the distribution agreement of 1965 as well as the one of 1968 designed first of all Dow France for delivery of the products to distributor. Although it has been provided for that deliveries could also be effectuated at the choice of the seller by other subsidiaries of Dow Chemical Company, it is to be noted that in fact it has not been sustained that this option has ever been used. It has always been Dow France which has assured the execution of the contracts. Dow France, therefore, played in the execution of the contracts an equally preponderant role as it did in the establishment of the contractual relationship. So this non-signatory was the center of the negotiations and played an equally preponderant role in the execution of the contract. Considering, moreover, that for exercising its contractual activities, the distributor necessarily needed to make use of the trademarks belonging to the parent company, Dow Chemical Company, though no special license agreement appears to have been concluded. This situation shows the primary involvement of the parent company in the distribution agreements. The same significance can be attached to the clause, which has already been mentioned, and according to which deliveries could be made by any wholly owned subsidiary of Dow USA. The clause shows, in fact, that the parent company was the pivot of the contractual relationship finally established between certain entities of its group and the distributors. Then the third factor, termination of contracts. That it thus appears, as was the case with respect to the conclusion and performance of the distribution agreements, that Dow Chemical France played an essential role in the termination of the 68 contract, which had been substituted for the 65 contract, that all of these factors permit the conclusion that Dow Chemical France was a party to each of these contracts and consequently to the arbitration clauses they contain. So cumulatively, Dow France's involvement in being the center of the negotiations, being the person who actually assured execution of the contracts, and being the company that played an essential role in termination, altogether made it effectively a party, a veritable party. Similarly, the next paragraph, that the same conclusion should be reached with respect to Dow Chemical Company USA by reason of its ownership of the trademarks under which the products were marketed and its absolute control over those of its subsidiaries that were directly involved or could under the contracts have become involved in the conclusion, performance or termination of the litigious distribution agreements. I rely on this para because there's a finding of absolute control. In the Vodafone case, as your lordships have said, that even holding 100% of the shares of a subsidiary ipso facto doesn't lead to piercing of the veil. A legal control is required, something more than a persuasive position. So here there's a finding of absolute control. And then, considering that the defendant adopted the same position in its brief of so-and-so before Court of Appeal of Paris in support of its motion of compulsory joinder of Dow Chemical Company, that the defendant there in fact wrote as follows. This is Isova, who was opposing the claimant. Whereas Dow Chemical Company, owner of the patents and organizer of the manufacturing and distribution of Roofmate, decided and conceived the modalities of the manufacturing and distribution of the said product, thus engaging its direct liability. So the parent company conceived of all this, the manufacture and the distribution, and therefore engaged in a direct liability. Next page. I'm sorry, the last sentence of the preceding page. Considering that in the circumstances of this case, the application of the arbitration clauses to Dow Chemical Company USA may also be justified, as we shall now show, by the fact that the contracts containing these clauses concern, in the context of a group of companies, a parent company and certain of its subsidiaries. The same fact would justify, if necessary, the application of the arbitration clause to Dow Chemical France, then group of companies. Considering that it is indisputable and is in fact not disputed that Dow Chemical Company USA has and exercises absolute control over its subsidiaries, having either signed the relevant contracts or, like Dow Chemical France, effectively and individually participated in their conclusion, performance and their termination. considering that irrespective of distinct juridical entity of each of its members, a group of companies constitutes one and the same economic reality of which the arbitral tribunal should take account when it rules on its own jurisdiction, subject to Article 13 of the ICC rules, considering in particular that the arbitration clause expressly accepted by certain of the companies of the group should bind the other companies, which by virtue of their role in the conclusion, performance or termination of the contracts containing said clauses, and in accordance with the mutual intention of all parties to the proceedings, appear to have been veritable parties. This is an expression that comes from a veritable parties to these contracts, or to have been principally concerned by them and the disputes to which they may give rise. And then in the next few paras, they say that in fact, there were other awards also, where sometimes it was held that these companies in the group were bound, sometimes it was held they were not. And in one award, they noticed it was not, because there was not that level of involvement. And the last para on that same page, in so doing, the tribunal contradicts no principle nor any rule of international public policy, in particular that of the French legal system. The latter is not based on any principle, nor does it contain any rule of such a stature that would prohibit giving to an arbitration clause implicating companies that are legally distinct but form part of a group of companies the scope attributed to it by the present award. To the contrary, by taking into account, in reaching this result, the needs of international commerce to which the rules of international arbitration should be responsive, the tribunal follows the example of French case law, to which express reference was made in the report to the Prime Minister, etc. So the tribunal is very conscious that all this can be done within the matrix of the law, including French law, which govern who are going to be parties to that. Therefore, what does essentially this award do? It said parties who were not signatories, but who were centrally concerned with negotiation, performance, and termination. Parties who everyone considered were veritable parties. The non-signatories themselves considered themselves to be contracting parties. The signatories considered them to be contracting parties. They would be bound by an arbitration clause and could take advantage of it equally, both ways. Here they were trying to take advantage of it. And the signatory was saying, no, I never signed an arbitration agreement with. How can you let them come and make a claim against me? So the genesis of this doctrine is a mutual intention of all parties, signatories and non-signatories. A mutual intention of only signatories is not enough. An intention only of non-signatories is not enough. And this Honorable Court has followed these principles. I'll show that from chloro controls, etc. Now, it is therefore a theory based entirely on becoming a party to a contract, because an arbitration agreement is a contract, by mutual contractual consent. Everyone has consented by conduct. They've not written it, but by conduct and the way everyone has treated it. And then one of the parties can't back out of such a consent which could be implied constructively from conduct. That is the limited, narrow area of this doctrine. And as a later authority points out, I just want to place that article, that it's a doctrine really that is founded on consent. In fact, the critique of this case is that the fact that it was a group of companies was just one factor. It was really consent that was the main factor. So though the theory is called group of companies doctrine, it's really based on consent and a mutual intention. And I just want to place that article because it's a very good analysis. Please treat it as my submission to your lordships, which is a Professor Hanish's article found at page 152 of the same compilation. It's written recently on 40th anniversary of the Dow Chemical Award. And I'll just point out a few passages. At page 153 of the compilation, the paragraph on the top, about halfway through that paragraph, the para starts with as to the subjective scope of the arbitration agreements, but about halfway through, rather it found that the non-signatories appeared to be true parties to the contracts. it concluded that this was the intention of the parties, both of the claimants and of the companies which were eventually succeeded by the respondent. The arbitral tribunal followed a two-step approach to determine the subjective scope of the arbitration agreements. First, it analyzed the factual circumstances underpinning the negotiation, performance. Running the first paragraph.
53, the page begins with circumstances.
I'm applied. Then the next para is as to the subjective scope.
Correct.
So about halfway through that para, the word sentence starting with rather. Rather, it found that the non-signatories appeared to be the true parties to the contracts. It concluded this was the intention of the parties, both of claimants and of the companies which were eventually succeeded by the respondent. Arbitral tribunal followed a two-step approach to determine the subjective scope of the arbitration agreements. First, it analyzed the factual circumstances underpinning the negotiation, performance, and termination of the agreements. Second, it considered what bearing the circumstances that the companies belong to the same group should have in that context. Throughout both stages, the arbitral tribunal focused on the parties' intentions. While analyzing the circumstances of the case, the arbitral tribunal found that both non-signatories played an important role in the agreement's negotiation, performance, and termination. Then the one paragraph after that, starting, it was only after the arbitral tribunal reached the conclusion that the non-signatories were also parties to the agreements that it proceeded to the analysis of the impact that the existence of a corporate group might have upon the arbitration agreements. In this regard, it is important to mention that the arbitral tribunal found that an arbitration agreement signed by certain companies should be binding on other entities of the group only where the latter seem to be true parties to the arbitration agreement by virtue of their participation in the negotiation, performance, and termination of the contract, and if this corresponds to the parties' intent. It's a very important caveat. So it's not that one can just see a group. For example, the Tata Group or the Birla Group. You enter into an arbitration agreement with one company. It doesn't automatically rope in every other company. Or you can't pick and choose. It has to be a company in the same group who has been intimately concerned with all these aspects.
Pivotal role is...
Pivotal role. These are descriptions.
Yes.
I'm not, it's
we can't
written
sort of
stone.
using a particular word, but then we understand the...
So important role in negotiation, performance, and even in termination if that is the position. Then if we go to the next page, the section starting with no creation of a group of companies doctrine. Over the last 40 years, much has been written. Over the last 40 years, much has been written about the so-called group of companies doctrine, a theory allegedly originated from Dow Chemical case used to bind third parties to an arbitration agreement. However, no consensus has been reached as what should be understood under the group of companies doctrine. Neither its concept nor its contours are clear. An analysis of literature and case law reveals that completely opposite conclusions have been drawn from the Dow Chemical Award. On the one hand, the group of companies doctrine has been criticized and its application has been rejected by courts and arbitrators that considered the group of companies doctrine a non-consensual basis for extending the arbitration agreement to companies of the same group, irrespective of the party's intent. From this perspective, the theory would be a violation of the consensual nature of arbitration. On the other hand, some commentators take the view that consent is at the heart of the group of companies doctrine. They see in it a basis for finding implied consent based on objective patterns. In light of these conflicting views, the term group of companies doctrine is clearly ambiguous. Hence, it is not surprising that discussions regarding the existence and applicability of such theory quite often lack clarity. Not only equivocal, the group of companies doctrine is also a dispensable concept. The idea that the Dow Chemical Award created a non-consensual basis for extending the arbitration agreement is a misconception. As shown above, decisions rendered by Arbitral Tribunal and Paris Court of Appeal actually rely on consent. They did not give origin to a theory allowing the extension of the arbitration agreement beyond consent. And then the last two paras on that page, furthermore, Furthermore, had the group of companies doctrine a consensual nature, it would be only an unnecessary term, adding complexity to what is in fact the assessment of the party's intent. Attaching any consensual requirement to the theory would render it meaningless. Consent is the fundamental and utmost requirement in any case. If there is consent, there is jurisdiction, so that no further requirements would be necessary. In other words, if there is express or implied consent, then the party will be a true party to the arbitration agreement without needing to resort to any theory. This does not only apply to cases where the companies are from the same group, but also where the companies are completely disassociated from one another. The existence of a group of companies is therefore only a factual element that might indicate consent towards multi-party arbitrations. It is certainly a factor to be taken into account when analyzing the parties' intentions, but it is not a decisive element by itself. Consent remains the preponderant criterion. And the last page, 155, conclusion. Dow Chemicals Award landmark decision, it provides clear reasoning as to the fundamental role played by consent in determining the subjective scope of the arbitration agreement in multi-party arbitration. In this case, the arbitrators decided that the companies might be bound by the arbitration agreement entered into by other entities of the same group if the non-signatory companies appear to be true parties to the arbitration agreement by virtue of their involvement in the negotiation, performance, or termination of the underlying contract. Dow Chemical Award did not create a basis for extending the arbitration agreement to third parties irrespective of their consent. In fact, exactly the opposite holds true. The arbitrators found that an arbitration clause might bind a party that has not formally entered into the agreement only insofar as this is in accordance with the parties' mutual intentions. This contradiction puts the existence of a so-called group of companies doctrine into question. In 40 years, the term group of companies doctrine has proved to be misleading and the idea of such a theory a misconception. The fact that two companies are part of the same group does not serve as a basis for the extension of the arbitration agreement on its own. Whether a party can invoke or be bound by an arbitration clause is a matter of consent, which shall be ascertained case by case based on factual elements. This does not mean existence of a group of companies is irrelevant. Quite the contrary, it is certainly an element to be considered in the analysis of parties' intentions, but not decisive per se. Now, I am adopting these as my submissions. And in my submission, when I show chlorocontrols correctly read, it is what chlorocontrols itself has said in many ways. And the only thing chlorocontrols has actually left out is the requirement of performance, which my lords have now added rightly in the discovery matter, ONGC discovery. That fifth element has now come in. But what is important is that these are cumulative elements. It can't be a pick and choose that they're part of a group of companies. It matters not that there's some peripheral involvement in negotiations. That's all. They are roped in because one or two of the factors are satisfied. These are all to be seen cumulatively. And the conclusion has to be reached that with these factors, there's an implied consent and they're true parties. Without that conclusion, there can be no joining of any party to an arbitration because that would defeat another cardinal principle of consensuality. A non-signatory might say, I never agreed to go to arbitration. A signatory might say, I'm sorry. When I show the provisions of our Act becomes very critical. Because our Act requires the provisions of the Contract Act to be complied with. So without consent, you can't have a contract. If my lords would kindly now turn to my note, maybe quicker if some portions I will just take from my note. I don't want to trouble my lords to see. Everything is here in the compilation, but if one would kindly go to page 4 of the note, the passage marked common intention. I've referred to the UK Supreme Court decision in the Dalla case. This was a case on slightly different facts because here it was a very odd case, my lords of course know, where award arbitration seated in France came for enforcement to England. England has special laws where jurisdiction is tried de novo in court by the enforcing court with evidence being led and everything. So they held a mini trial and they held contrary to the tribunal saying, no, according to us, tribunal had no jurisdiction, we won't enforce this award here. 1 month later, the court of the seat in France affirmed the award. So it's that case. But in that case, they had occasion to comment upon what the French law was. And I'm only relying on those observations because they are relevant to our case. So the UK Supreme Court was applying French law to test whether an arbitration clause, this is para 8 of my note, whether an arbitration clause upon which the jurisdiction of the tribunal is founded extends to a person who is neither a named party nor a signatory to the underlying agreement containing that clause. And I quote, the Supreme Court held, whether all the parties to the arbitration proceedings, including that person, had the common intention, whether express or implied, to be bound by the agreement. This was a case where the Pakistan government had set up some public trust, and the contract was entered into by the trust. The other company, which was a Saudi construction company, said effectively we are dealing with the government. This trust is only an instrumentality of the government. And though the government may not have signed the arbitration agreement, we are entitled to join them to the arbitration. Government of Pakistan took a jurisdictional objection, saying we are not signatory parties. So under French law, this was the analysis of the French law done by the UK Supreme Court even, which said, therefore, all the parties had to have the common intention. And then the common intention of the party in turn means the subjective intention derived from objective evidence. Objective evidence includes the involvement and behavior of all the parties during the negotiation, performance, and if applicable, termination of the underlying agreement. Then Redfern and Hunter said effectively the same thing. 3 conditions. Whether the non-signatory actively participated in the conclusion and execution of the contract. Second is, has a clear interest in the outcome of the dispute. And 3 is a party to the contract that is intrinsically intertwined with the contract under which the dispute has arisen. And Gary Vaughan has said the same thing, that at bare minimum, the non-signatory's intention is the most important. The signatory's intention will be housed in the contract. My lords know, as a matter of interpretation of contract, one sees the contract primarily. So that intention is easier to ascertain. It's the non-signatories that's more difficult, and various tests have been evolved. And I've just for convenience shortly put out in para 12 what your lordships did in chloro controls. In para 71, if the circumstances demonstrate that the mutual intention of all the parties was to bind both the signatories and the non-signatory affiliates, and where there was a clear intention of the parties to bind both signatory and non-signatory. Now, if this is the doctrine which our Supreme Court has squarely accepted, derived from Dow Chemicals, your lordships have said mutual intention is a requirement. Maybe now with this background, turn to the Arbitration Act. Where does it fit in under our Arbitration Act? My lords, will recall only one thing. Arbitration is a statutory exception to the doctrine of restraint of legal proceedings. Section 28 of the Contract Act has an explanation saying, other than arbitration, any contract in restraint of proceeding will be void. So it saves a contract from voidness, that it has to be an arbitration agreement.
Mr. Kambata, I would like to read your note at page 6 because we formulated it, and then you can...
Yes, may I read that?
That will be...
So may I read from the bottom of page 5?
Yes.
An arbitration agreement excludes the jurisdiction of a civil court, including under Section 9 of the Code of Civil Procedure, and takes away the right of a person to approach a civil court. Such an exclusion can be made either by statute or by contract only. An arbitration agreement, therefore, must satisfy the requirements of the law of contract, which is the Contract Act. Under Section 2 of the Contract Act, the following would be essential for formation of a contract. 1, a proposal. 2, acceptance of such proposal, making it a promise. 3, a promisor and a promisee. 4, consideration for the promise. 5 reciprocal promises forming an agreement. And in Vidya Drolia, your lordships held that an arbitration agreement must satisfy the prerequisites of a contract under the Contract Act. That is in addition to Section 7. It must contain promises forming the consideration for each other. It must be made free of consent between parties competent to contract for a lawful consideration of the lawful object, and it must be enforceable by law. Now, straight away when we talk about contract and third parties or non-signatories, doctrine of privity comes to mind straight away. The third party can never enforce a contract, nor can it be bound by it. And there are various well-settled exceptions to that. Our Supreme Court in MC Chaco has said third party cannot sue or be sued unless the exceptions to the doctrine such as trust, family arrangement, assignment are attractive. But for convenience, I'm not going to take him around, but some of the important cases we have graphically analyzed in annexures. It's just because some of the facts are usually so complicated that it's easier to do it by way of a graphic, and therefore we analyze MC Chaco, where Kottayam Bank was not a party. And it was held, it's neither a beneficiary of a trust nor part of a family arrangement. It was not allowed to enforce a contract whereby members of a family had agreed between themselves to pay off dues to Kottayam Bank. Now, privity of contract and the exceptions to it, both under our law and English law, does not admit of this so-called group of companies doctrine. There is no such exception. So, the group of companies doctrine is something outside the law of privity of contract. And it seems to be on a slightly different basis. Privity of contract is a third party to a contract cannot enforce or be enforced against it. Group of companies doctrine says this is not a third party. This is effectively a party, a real party. So unless you reach that conclusion, one would fall foul of the doctrine of privity. The court has to reach the conclusion that this is a real party or a veritable party. Short of that, a factor here or a factor there is not enough. Now, may I proceed further, para 19. Arbitration in agreement in restraint of legal proceedings would be void, section 28. Specific exception is carved out for arbitration. Exception 1. Saving of contract to refer to arbitration disputes that may arise. This section shall not render illegal a contract by which two or more persons agree that any dispute which may arise between them in respect of any subject or class of subjects shall be referred to arbitration, and that only the amount awarded in such arbitration shall be recoverable in respect of the disputes so referred. Therefore, two or more persons are required, and they must agree to refer any dispute which arises between them to arbitration. So the non-signatory party must come within these two or more persons. That is to say, it must be treated as a party. Short of reaching that conclusion, one can't rope in a non-signatory. And because there is, my lords know, I have not cited this, well settled, Arbitration Act is a complete code. It's exhaustive of the law of arbitration. So unless it is a valid arbitration agreement under the Arbitration Act, there's no other arbitration outside the Arbitration Act by which one can bring in a non-signatory or non-consenting party. Now, even enforcement of a contract, this is interesting in the Specific Relief Act. When we are dealing with companies, there are only two categories that have been roped in addition to parties. Section 15, which is who can enforce a contract, permits enforcement of a contract by a non-party company in only two cases. One is subpara G, amalgamation. So company A enters into a contract, ultimately amalgamates with company B, and the amalgamated company can enforce that contract. And H is pre-incorporation contracts, when promoters enter into it before incorporation of the contract. Again, the Specific Relief Act has no such category or residual category even of a non-signatory company because it belongs to a group and it may have been involved in something becoming a party which can get specific performance. And section 19 is the other way around. Against whom can you obtain specific performance? Again, only these two categories. So again, I point out, I'm not for one moment suggesting that the group of companies doctrine still can't be incorporated. But it has to reach the result of a conclusion by the tribunal or by the court that this person is nothing but a party. Only the formality of signature remained. Short of reaching that conclusion, there is no way within our matrix of law that one can bring in another type of hybrid type of a party against whom or who can enforce specific performance. Now let us come to the Arbitration Act. Because in my respectful submission, the Arbitration Act actually narrows what is found in the Contract Act. And I'll tell my lord's part. 2(1)(h) only says party is a agreement, there's no restriction there, and there's no restriction of signatory. Can be someone who doesn't sign. 2(1)(h) we've seen does not incorporate the Law Commission's recommendation of claiming through order, but at a certain level that's not critical to your lordship's analysis. Because we are seeing claiming through order is a derivative character, whereas here we are trying to see who is the real party or the true party, which is not a derivative character. In a derivative character, the cause of action would belong to the original signing party, and only someone claiming through order in that very character would come in. Whereas here we are saying the third party who has not signed has its own cause of action, or there is an independent cause of action against it, not derivative. Therefore, this point is there, we've argued it, but at a certain level, my lords may take it that true order is not determinative of the answer to this question that faces the Constitution bench. Now, I've set out from paras 23 to 27 this concept of the definition of party. In para 28, of course, I've referred to the requirement of consent and the party autonomy being the backbone. As one US Supreme Court judgment had put it, arbitration is a matter of consent, not coercion. Puts it very nicely. There's no mandate of the law that you are a party. It has to be housed on consent and founded on. Without consent, you can't have arbitration, unless it's a statutory arbitration. That's a different category. Now, please see may I just show the provisions of the Arbitration Act?
Yes.
If one goes now to section 7, what we were just saying this morning. 7.1. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes. I pause here for a moment. These words describe the contract of arbitration, the arbitration agreement. Now, the following words say what the character of those disputes could be, which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. As my Lord the Chief Justice said this morning, this is the source of the dispute. And that's a nice way of putting it. The subsequent words are, where does the dispute come from? It must come from a defined legal relationship, whether contractual or not. And one can think, in fact, it fell from the bench in the morning. There are various examples. Quasi-contract, section 68 to 72, all those, quantum meruit, monies had and received, all those are not contracts, and yet a dispute could come from them. Family arrangements, partition suits, all those are disputes where there is no contract. Trust could be another area. And of course, now there is a fourth area, which your lordships in Vidya Jolia have contemplated, that even in personam disputes arising out of an in rem right can be the subject matter of arbitration. So it could be an IPR dispute where whether the trademark or the patent is validly registered can never go to arbitration. But that's a matter in rem. But if there's a dispute between parties or an infringement dispute, that could potentially go to arbitration. It's an in personam dispute. Again, that sort of a dispute is not housed in a contract. It could be from a license agreement, but it could be just two parties using the same mark. Therefore, the Act rightly says that you need an arbitration agreement, which has to comply with the Contract Act. That agreement can be in respect of either contractual disputes or even non-contractual, as long as there's a defined legal relationship. Now, that's all right. 7.3 says an arbitration agreement shall be in writing, and 7.4 says an arbitration agreement is in writing if it is contained in A, a document signed by the parties that requires signature, B, an exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means which provide a record of the agreement, or C, an exchange of statements of claim and defense in which the existence of the agreement is alleged by one and not denied by the other. Now, it is going to be my submission, and I hope I can make it good, that 7.4 is exhaustive of 7.3. And I'll show from the UNCITRAL model law and from other statutes why this is so. In other words, the agreement in writing has to be in one or the other of the three forms, A, B, or C. And straight away, may I say that this itself does not exclude the group of companies doctrine. Because B, for example, exchange of correspondence. It can be that a non-signatory party has exchanged that correspondence where it is effectively shown that it's a true party.
But 7.4 may not be exhaustive of 7.3. 7.4 may be an illustration of 7.3 also.
That is a possible argument. My lord is right. But please, if my lord sees my note.
Because 7.3 says that an agreement, an arbitration agreement shall be in writing. It's the norm.
Correct.
And 7.4 provides for instances
exactly.
where an arbitration agreement is.
Exactly.
Of course, there's one thing which is there, which doesn't say it shall be deemed to be in writing if. It says is in writing if.
If it is contained. The word if is used. And something may turn on that. So I want to place before my lords the UNCITRAL model law.
But it's not necessary for us to unduly restrict 7.4 by saying that these are the only instances where an arbitration agreement will be deemed to be in writing.
I understand that. That, of course, your lordships will determine. But may I just place some material which might be of assistance to my lords in that exercise? In my compilation...
I'll tell you why.
Yes.
This was actually worrying me in the morning. 7.4b refers to an exchange of letters, telex, telegrams, or other means of telecommunication, which provide a record of the agreement, right? And C then refers to claim and defense. Now, B provides an extremely limited. A is a document which is signed. B refers to only an exchange of letters or electronic means of communication. Now, there may be other circumstances where there is no exchange of letters or an electronic communication or a physical communication between the parties. Where, for instance, I'll tell you, suppose there's a measurement book in a contract. That measurement book will not fall either in terms of a document which is signed by the parties. It will certainly not be an exchange of letters. It will not be an exchange of statement of claim or defense. So there may be other conceivable circumstances in which parties may, by writing, agree to an arbitration, which is neither a letter or exchange of correspondence, nor is an exchange of a statement of claim or defense, nor is that document signed by the parties, but which may still be in writing.
I see what falls from my lord.
It could be a record of
agreement.
But it's a record of an agreement.
So long as it is a record of the agreement.
That's right.
That's why I told you a measurement book.
Correct.
So,
measurement book
so therefore, these three instances which are prior to record of an agreement is not exhaustive. The keywords are record of agreement.
Correct.
What is a record of agreement? There are instances like exchange of letters, telex, telegrams, and other means of telecommunications, including through electronic mode, are instances of a record of agreement. Which could be,
and therefore B could be read.
And the absence of the word only in 4.
Yes.
Is again, just as you have the absence of the word signatory in 218.
Yes.
And the absence of the word only in 7.3, in 7.4. But an arbitration agreement is writing only if it is contained. Correct. Then you would have been right. But that word only is absent.
Maybe obtained by seeing the UNCITRAL model law, which underwent the change. I'll show both. Because our act is based on the model law, and your lordships have held repeatedly that the model law is an appropriate guide to interpretation. It can be looked at. If we just see the model law as it first was, in 1985, that is page 637 of this compilation, What is the equivalent provision there? And then what is the change?
Right. I have one small doubt.
Yes, sir.
See, this expression, the real rubric which you are placing so much reliance on is consent, correctly.
Yes.
But then consent is also a little amorphous. Should it not take color from the Contract Act till it actually becomes a contract? That is, should it also definitely not constitute principles of promise?
Yes.
Which is, should it not have offer and acceptance?
Yes, I'm obliged.
So therefore, one has to see under the definition of 2E, F, G, H, I, leave alone J of the
Correct.
Contract Act,
My lord is right.
where a third party becoming a part of an arbitration, it needs to be concluded by the court that there is this semblance of reciprocal promises or offers and acceptance leading to an agreement.
Yes, I'm obliged.
You don't need any further.
I'm
Leading to
obliged.
an agreement, and all this could be sourced from the record of agreement.
I'm obliged. But may I adopt that as my submission? I put it a little inartistically. My lord is
It
right.
must be there.
Yes,
It's not just saying the consent is there means consent.
correct.
What
It has to be a consent
consent can't
amounting
be
to
anything but a
contract,
consent.
which is why
Consent evidencing. Let us use this very expressions. Every set of promises forming the consideration
yes,
from each and for each other as an agreement. Promises which form part of the consideration or part of the consideration for each other are called reciprocal promises. An agreement not enforceable in law will be void. An agreement enforceable is a contract. At least offer and acceptance.
My
Again, Contract Act defines offers and it also defines acceptance and how it is completed.
and an arbitration agreement has to first be a contract.
And again,
No, it may not be a
consent.
contract. Sorry.
It may or may not be a
It
contract.
need not be a contract. So that is another doubt I have.
That's 7.5.
No, may I then sir, I'll come back because your lordships in Vidya
The
Drolia.
contract may not
Yeah,
contain an
yeah.
arbitration.
Contract like Vidya Drolia, general observation that it's a contract, but it does not really, they have not gone into it, to be fair to the bench. The question didn't arise in Vidya Drolia as to whether Arbitration Act is confined to a contract, which is agreement enforceable by law.
Maybe see 7.1 again for a moment.
But that's not really a.
I understand. No, I mean, these are issues that will arise. I invite such questions because this is correct. It enables me also to formulate.
Good. Actually, according to me, Arbitration Act must be wider than what Contract Act.
No, not
is, so that you can
arbitration-
have an arbitration even with respect to non-contractual relationships.
No, of course. I'm sorry. That's why let's go back to 7.1. I'm not saying that you can't have an arbitration agreement in respect of a non-contractual dispute. That's not my submission. 7.1, an arbitration agreement
It's a matter of contract.
contract. But it can be, I agree to arbitrate disputes of partition, a family matter. I agree to arbitrate disputes of quantum merit.
One is what can be the subject matter of the arbitration.
Yes.
The second is whether to go to arbitration.
Has to be a contract.
The contract.
Has to be.
Once parties have, what you're saying is, once parties have agreed to go to an arbitration, then the context of the arbitration, the content of the arbitration
Can be much wider.
Well, it may be, as I said,
Can be much
between two brothers on partition, may be the subject.
In fact, it's not in public, it will be contrary to public policy to narrow that content.
So, in other words, Section 7,
Yes.
you're saying arbitration, the heading is arbitration agreement.
Agreement.
So, you're saying it should be read as arbitration contract.
Contract. Yes. And that is the basis of any arbitration. It's very well settled that arbitration is a contractual means. As I said, apart from certain statutory arbitrations, which are matter of statute.
The MSME Act.
Correct. That can be different. I'm not saying that is overridden. In fact, the Arbitration Act itself contemplates statutory arbitration.
Or in Madhya Pradesh, you have a statutory form of arbitration.
Correct.
For all public disputes.
Correct.
That's different. That's
different. I'm not saying that, of course, that works. We are talking about contractual arbitration in part 1. And section 7 deals with contract meaning the arbitration agreement has to be a contract. But that contract can allow arbitration of disputes, not only in contractual disputes, but other disputes as well, as long as there's a defined legal relationship. So I'm not for a moment suggesting that the scope of the
But
agreement
really, the group of companies doctrine is an effort to locate who is a party to the
is the
contract.
party.
Right. And in locating who is a party to the contract, you go beyond the signatories to the contract, where
Yes.
the conduct of the party, which again has to be evinced in writing, having regard to the provisions of Section 7, shows that there was an intention to bind non-signatories both by parties who are signatories to the document as well as the third parties who are not
So,
signatories.
for example, it could be that a non-signatory has an exchange of letters, telexes, etc., recording the arbitration agreement and indicating that it impliedly that it's consenting to it. That would come within the doctrine. It would come within our Section 7. I'm not saying it wouldn't.
So suppose there's a contract between A and B,
Yes.
and C has aliened by its conduct or whatever, indicated that I affirm this contract,
Yes.
that I stand by this contract.
Yes.
And how do I stand by this contract? Either in terms of the stage of the negotiation of the contract, the performance of the contract, or the termination of the contract. In which event, C has clearly indicated that, well, it is really as much a part of the contract as A and B.
I'm okay. That is my argument. So mine is really a mid path. I'm not on this side or that side. Look, someone asked me this morning, are you for group of companies or against? I said, I can't answer that question because my argument is an intermediate argument.
No, but you are not saying that there is no group of companies doctrine in our law at all.
I'm not saying.
You accept the fact that there is a group of companies doctrine.
Yes.
That this is really a legitimate extension or it is within the statutory mandate. But the contours of the doctrine have to still comply with the essentials of the...
Yes, with Section 7 and of course with the provisions of the Contract Act.
Group of companies is one instance.
One more question. One of the interveners, one of the young lawyers argued it on this, I think Pallav Mongia, I'll just tell you who. Why confine it only to parties who are part of a group of companies then?
That is in fact what Professor Hanushu's article also says. That it may not be confined to parties within a group. The group of companies doctrine is evolved in this manner.
You are sourcing from these statutory.
Makes it a little easier in terms of the fact that the benefits of the contract are emanating within an...
It may be one of the factors. There's no question. It may be one assistance to a person determining whether this is a real party or not. But take a totally different case, a back-to-back contract. Where the two A has a contract with B who has a contract with C. So AB is back-to-back with BC. Now A and B may not be part of the same group at all. They may be totally independent companies.
They would still be bound.
But if one could show some correspondence where A commits to C that I am bound by your contract with B and the arbitration clause in an implied way. I'm not saying the language has to be so express. Then one could say that A is also bound by that arbitration.
Irrespective of whether A and C were part of the same
group or even whether A and B were part of the same group. Yes. So it boils down to finding a contract by conduct or consent. And one of the factors which may assist along the way is it's a group of companies.
Group of companies could then be just one of the factors, but here by conduct and consent.
Yes.
People who may not otherwise be seen as a group
Precisely.
would also be roped in.
Precisely.
So if that happens, then this group of companies doctrine could just be an element in analyzing whether they could be roped into an arbitration proceeding.
Precisely.
So the existence of a group of companies is not a sine qua non for bringing a non-signatory to an agreement within the fold of the arbitration agreement. The existence of a group of companies may be an additional factor to show that because they were all part of one economic entity, the broader corporate group, for instance, Therefore, say a parent stood by the contract which its subsidiary was entering into or an affiliate was entering into.
That may assist the tribunal or the court. But that's not the search is for finding who is the true party. Is it a true party?
It's in other words evidentiary and not normative.
Precisely. And that will subserve
Like
the corporate law principle that a group structure can be devised.
I was just recalling this. Competition Act Section 3
Yes.
talks about the definition of anti-competitive agreements. Just generally, I may be wrong, but I'm just sharing. It encapsulates the concept of what are anti-competitive agreements. Having said that, it gives 5 instances, which are actually cases where bid rigging, collusive rigging, and so on. So those are actually per se cases. If there is a case of bid rigging, automatically it will become.
That's right.
Like in this case, a group of companies and certain other instances will automatically be, but it has to be actually sourced to the definition of the statute to see if those conditions are satisfied or not.
Yes. The problem for why I'm raising this is, what is happening is, groups of companies, you may have even a common promoter. I'll come to that later. What is happening is we have a group of 2 companies with a common promoter. One has entered into the agreement. The other is not a signatory. There are no obligations under the agreement, nothing. And they said, no, it's the same promoter. And therefore, it must be party to an arbitration. And with all the consequences. And listed entities are being dragged in. In fact, I'm appearing in a matter where it's a listed entity. It's dragged in on this ground. Therefore, there is need for some indication of what this concept means.
This concept means, again, we will have to be very, very clear about this. Consent.
Consent.
So then one has to pronounce the contours of a consent.
Yes.
So do we go back to the definition of Contract Act and then...
Yes, my lord. I would think that is necessary because...
Yeah, we will have to go to it. In every case, do we have to see which is the offer, which is the acceptance?
One would
What
have
is the consideration?
One would have to. Consideration is slightly different. As my lord knows, under our act, it can move from a third party also. From the promisee or any other person, 2(1)D of the Contract Act. So to that extent, it's not such a strict that there should have been consideration. But that test has to be applied. The question is, for example, a non-signatory member of the group. What is the promise it has made? It has to be seen. It's not a promisor. It's not a promisee. How does it get drawn into a contract of arbitration?
The court has to infer from contract to contract.
Yes, that is case.
Agreement to agreement.
That will be case.
So court will only be stepping into the analysis of the agreement and then saying, I will assume that this benefit A gets, the fallout of it is actually on C, who is eventually getting the benefit. So therefore, this works as a consideration.
But there also, my lord, there are 2 ways perhaps. One is beneficiaries. If there's some kind of a trust, then there has been a standard exception to doctrine of privity. You don't need to even go to group of companies. But say there is some indirect benefit. Does that make the person a promisor or promisee just by getting that benefit? One may be able to trace the various other instruments available. But does it make it a contract for arbitration? That is a question that has to be answered on a case-by-case basis.
Some presence or semblance must be identified.
Must be something.
We don't have to get into too much of it.
Otherwise, we are undermining the whole concept of arbitration. My concern is...
Well, see, we shouldn't make it too restrictive also, Suppose A has entered into a broader agreement with C.
Yes.
All right? C has entered into a broader agreement with A. So now A has entered into an agreement with B. C stands behind the agreement. C is interested in the success of the agreements which A will enter into with B, C, with B, X, Y, Z, because that is central to C's contract with A.
Correct.
Now, if C enters into the contract with A, conscious of the fact that the business venture between C and A is dependent in turn on the success of the venture between A and other third parties, and conscious of that, C holds out a representation that, look, I am there.
Yes, that my lord is right, but that would fall under an estoppel.
Stop.
a benefit estoppel, which is a different concept. And there I must tell my...
But these are all, in that sense, they're all, and these are all related concepts. Therefore, group of companies is not the only part, not the only situation in which you can include a non-signatory to the
One
arbitration.
would have to say that an arbitration agreement has arisen by virtue of an estoppel, and then the next question would be whether Section 7 covers such a contract. One may be able to sue the person on the grounds of estoppel. That who made this representation? I entered into this contract. I have suffered loss.
Therefore, Mr. Tushar Mehta had sort of A, B, C, D, E, F.
But today, seeing only our arbitration act, all those concepts can't be brought in unless they fit the bill under Section 7.
Obviously, you have to come
So the representation has to be in an exchange of letters. It can't be oral, for example.
No,
It can't be oral.
the question is to identify the principles for fitting the bill, because when we lay down the law, it should be, there must be some amount of certainty. So
Yes.
what is that minimum content that we are?
The minimum content is that
What is
there must be a contract in law which is entered into by the non-signatory by virtue of his conduct. But that contract to enter into arbitration has to be established. And the arbitration agreement can be housed in a document to which it is not a signatory, because there is a record of the arbitration agreement. So, simple case, A and B have a signed arbitration agreement. C can say in an exchange of letters that since I'm completely involved in the performance, etc., I accept that this is how our disputes will be resolved.
I think easier way to define it.
It need not sign. It could be a non-signatory party stated.
You can say 7.3 really is a norm, that it is.
But before that, may I just show one thing?
And 7.4 is the evidentiary burden that you have to display.
Yes, but please see the UNCITRAL model.
When it is deemed to be.
That throws a lot of light on how to read 7.3. Please just see the UNCITRAL model law at page 637 of the compilation, just for a moment. That may assist your lordships in how to interpret this.
I was just talking to my young brothers. We need not pressurize you to conclude today.
I won't be able to conclude.
No problem. We also have been asking questions. I mean, the reason we were asking questions, that helps us to regurgitate our own thoughts also aloud. And so how long roughly would you take on the 11th?
About an hour and a half.
An hour and a half. So if we start at about 11ish on, you can 12:30, you can...
yes, whatever. I'm in my losses. Whenever, or whichever day, whenever
because, 5th, 6th, we have miscellaneous.
Yes, sir. And 11th, my lord. Whenever, whatever.
We have
the first part of the country, one has to be here. There's no question of...
But 11th, we'll have to wrap up. 11th, yes. Because following week, we are starting with...
same-sex marriage.
Same-sex marriage, we are starting. We've especially fixed that matter.
In fact, as regards showing judgments, I only intend showing 2 or 3. The rest I've referred to in my note, I'm not going to repeat.
Now, what you wanted to show...
Yes, please see for one moment. 637.
In your compilation? In your compilation?
In the compilation. Article 7 of the UNCITRAL model law.
737?
Yes. 637. 637. And if we see Article 7, 7.1 is really similar to our 7.1, but 7.2 houses both our 7.3 and our 7.4 in one. It says the arbitration agreement shall be in writing. And it goes on to say an agreement is in writing if it is contained in the document. Now, please see the amendment that was made to this in 2006, which we have not incorporated in our act. And that, my lords, will find at same compilation, page 641.
That is the amendment of
the UNCITRAL model law, which was amended in the year 2006, but we still follow the old definition. And the difference may indicate what the original definition, which we follow, was meant to signify. So the new definition on the 7 is 7.3. An arbitration agreement is in writing if its content is recorded in any form, whether or not the arbitration agreement or contract has been concluded orally by conduct or by other means. Much wider. We don't adopt this definition.
just 1 second. Can we read it again?
7.3 at page 641 says that the amended UNCITRAL is an arbitration agreement is in writing if its content is recorded in any form,
Including oral.
much wider, whether or not the arbitration agreement or contract has been concluded orally or by conduct or by other means, which also shows that the three means prescribed in the original UNCITRAL model law, which we have adopted, are the three means by which the law intends the arbitration agreement to be.
But not the only three means.
Mr.
Kambata, you're right. I mean, frankly, there is intrinsic evidence to support your interpretation because it says an arbitration agreement is in writing if it is contained. That's a clear indicator.
If these are not the three means, then why would we list out?
I know, but we can still
leave it to your lordship. I'm not pressing it beyond the point. That is for your lordships. I'm just.
Justice requires us not to accept that.
But just one last
thing. An evidentiary requirement.
Please see the equivalent provision of the New York Convention.
Where is that?
Page 693 of the same body. Article 2.2. Again, a much wider definition.
693.
Article 2.2, the term agreement in writing shall include an arbitral clause in a contract or arbitration agreement signed by the parties or contained in an exchange of letters or telegrams. Shall include rather than if.
Article 3.3, is it? Bottom.
2.3. 2.2. I'm sorry, 2.2.
2.3.
At page 693.
2.2.
2.2. These were all available definitions. Parliament adopted the strictest of them all in our 7.3 and 7.4, which is retained even today. And your lordships have also held, or such, I can't say held, in all fairness, it has been suggested in your lordships' judgment in both Discovery and Charan. I'll place those. Not specifically decided. I'll be very careful. I cannot go so far as to say your lordships have decided this. Your lordships have not. But that is the suggestion that 7.3 is colored by 7.4. As my lord said, that's the evidence by which you prove 7.3.
One other way of looking at it is that 7.1 is actually defining the relationship in terms of defined legal relationship.
Yes.
7.1, defined legal relationship. As long as through the documents and what is specified under B, 4B, through the record of agreement, it could be shown that there has come into existence a defined legal relationship. In sense that there is a relationship which is existing, which is authorized by law, not something which is illegal.
Yes.
Something which has come out of the relationship between A and B, which has an implication on C, and that legal relationship has come into existence, is sufficient to call it.
Is sufficient, provided there's an agreement that disputes from that legal relationship.
Agreement is again inferable. That's of course, that's taken. Agreement is inferable from.
I asked myself, what if there's an exchange of letters where two parties say we'll become co-owners? That's a defined legal relationship. But they say nothing about how their disputes are going to be resolved. That the arbitration agreement has arisen. There still has to be some agreement as to the arbitration agreement.
Yes.
Okay.
lies.
In Dow Chemical, they were you just described the claimants, Dow USA, Dow France, and the Venezuela, and I think the Swiss company. But somehow I found that very interesting. They are part of a group of which Dow Chemical USA is the parent company. The three others are the daughters and granddaughters. So expecting that the grandfather would stand by or should stand by. And in that case, the grandfather should also be liable for the.
And the grandfather had all the trademarks. Without those trademarks, that could never have been performed.
That's right.
Well, what is right
So we'll continue on the 11th.
I'm grateful to my Lord.
After that, Mr. Diwan will.
I would address your question.
And then we'll hear.
Whoever's there, start.
Take.